Hi, it's me, Professor Kit Chan. I'm an intangible asset lawyer. So today I'm going to share with you what is intellectual property. And to start with that, I think that maybe you would read a lot about patent, copyright, trademark, trade secret, all these various forms and make you feel drowsy. And don't feel frustrated. I'm going to share with you a slide and hoping that by the end of this particular video, you will have a more clear form. So intellectual property actually occurs in different way. A very fundamental pillar of that is called patents. Patents are used to protect enabling ideas, right? There's a step called creating the particular idea is called conception. So we have all these different jargons to describe this idea. The idea itself could be very simple, but it has to be enabled. So we actually separate there also subdivision of different form. Some of them are design patterns, which are actually mainly for the look and how do you really design it. A very interesting, even a mouse, right? So I'm holding on the mouse. There's some element that is functional. There's some element is for the look of it. And in general, when we just talk about the US scenario with the so-called utility patent, that's what we really understand mostly, that a very big chunk of patents are actually utility patents. Plant patent, which is actually very special, it only protects things in the plant. And in some jurisdiction, in some country like Germany, China, and Japan, there's something called utility model. Sometimes, not all the time, people would describe the utility model as a small invention instead of big invention. As a name that this nickname calls, so there's a little bit different. The regular utility patent, which may usually be 30 page or whatever, and then usually a utility model is a little bit simpler. But the hurdle, depending on jurisdiction, it would be different. Right? But all in all, it's a little bit lower than the regular patent. Particularly in China, it's called their utility patent. It's being called an invention patent. Then there's another form. There's a trademark. Then you have to really separate that with whether this trademark is mainly for products, it's an identification of product, or we actually would then name it mainly. Those are the key things in terms of the trademark. But what is trademark protecting? So by recognizing the mark, then you would know that what kind of goods that you are consuming. You're drinking Coca-Cola. You're not drinking a Pepsi-Cola, right? Copyright, I think copyright a lot of people would do. You really read the news, read the newspaper and all that. And the particular property of copyright has to be original. So sometimes some copyrighted material, it could be very similar but different. So it have to be original. So you cannot just simply say, that, oh, they do a very good stuff, very good drawing, so that I'm going to imitate it. Okay, so when I follow my children to learn the painting class, then the teacher always said, oh, follow this, just copy this. But copyright is a very important component, particularly now the software industry. We always talk about algorithm, with the AI, and so on. Trade secret, Coca-Cola again. What are we drinking? The darkish stuff. We do not know the exact formula of Coca-Cola. And the Coca-Cola, in order for you to protect it, you have to really have some degree of measure for the trademark. That particular secret has really helped you to really gain some competitive advantage in the business sense. And then you have to have certain measure. Now, do not get confused, right? Patents are protecting your enabling idea. Now, copyright cannot protect their ideas, right? There's a very well-known way of losing weight. It's called the Atkins method, meaning that stay away from the carbohydrate and so on. So Atkins ending up published a book. So if you copy their book, it's a copyright infringement. But if you practice the method, you're not infringing their copyright. So you cannot really say, oh, I got this patent, and so that I would label everything with whatever the patent. But there's a patent marking, meaning that do not touch this area. In this area, particularly this microphone, this whatever, is protected by patent. You can mark it. But trademark is really the mark that you will put forth, right? Okay, here, This is a Zoom meeting. This is whatever. So you mark it to ensure that when the people buy it, people know what they're buying. So there's a lot of imitation product. Instead of saying it's Coca-Cola, they will say cola and instead of Coca-Cola. So it's also darkish. They try to really imitate it as a red label to confuse some consumer so that they can ride on the success of certain mark. And we have to really be clear which area is which areas, right? Today, we are now just walking these things through. We could really go deeper in my later video. So to recap, these are 4 body of law. Patent protect enabling idea. Trademark is identification of goods. Copyright is the originality, but it has to really fix in a tangible form. Trade secret, some procedure or ideas which will provide competitive advantage, but you got to have a system to protect this sort of secret. So it could include the so-called know-how and show-how. I hope that you will find that what we have just discussed is helpful. And if that being the case, please hit the button about subscribe and hit the bell so that next time when we have new video coming out, you will be notified. See you next time.